Hello and thank you for joining us here. This is Channel One Television. We're coming to you live from our studios at number 5 Ula Hansen Lane at Tesano. My name is Nanatufo Boateng and many thanks for your time. We have breaking news for you, and this breaking news is coming from the Supreme Court of Ghana, which has issued a directive for Parliament to stay the execution of the ruling by the Speaker Alban Bagbin, which ruling declares 4 seats of Parliament vacant. Now, the Speaker of Parliament, Alban Bagbin, yesterday, after having received a petition from the minority side of the House, gave his ruling on the matter. Now, this petition sought to have 4 seats of Parliament declared vacant. These seats will be that of Aguna West, which was held by Cynthia Morrison on the ticket of the New Patriotic Party. There's that of Suhum as well, also belonging to the New Patriotic Party. Then there was Amenfi Central, where Peter Kwachi Aka represents the people on the ticket of the NDC. Now, these 3 seats, these members of Parliament have decided or have filed nomination with the Electoral Commission to contest as independent candidates in the 2024 general elections, for which reason the minority filed a petition to the Speaker to have their seats declared vacant. The 4th one will have to do with the Member of Parliament for Fomena, who has so far been in Parliament as an independent candidate, having broken away from the New Patriotic Party in 2020. What we'll have it is that the Fomena MP, who happens to be the 2nd Deputy Speaker of Parliament, Andrew Esiama, has been caucusing with the NPP side, which is the majority side of the House. And so following his declaration to now contest the 2024 election on the ticket of the New Patriotic Party, the minority added him to this cohort of 3 to make it 4 and asked the Speaker to declare their seats vacant following their decision to contest the 3 as independent, and of course the Fomena MP Andrew Siama as an independent candidate. And so the Speaker ruled yesterday declaring these 4 seats are vacant, which automatically will mean that these 4 can no longer hold themselves as members of Parliament. However, prior to the ruling, the majority leader, Alexander Afenyo-Markin, had filed a petition at the Supreme Court seeking an interlocutory injunction on this ruling by the Speaker of Parliament. Today, the Supreme Court has heard this application or this case and has stayed the execution of the ruling of the Speaker of Parliament. And so by this, Parliament has been instructed to recognize and allow the 4 members of Parliament to represent their constituencies and carry out their official duties. And so what the Supreme Court has done is to direct Parliament to respect the representation of these 4 members and of course the constituencies that they represent, and continue to allow them to work as MPs representing these constituencies. Now, this directive will remain in effect, of course, not for the 10 days initially requested by the applicants, but until the Supreme Court makes a ruling on the substantive matter in court. And so the big news here is that the Supreme Court of Ghana, that's the apex court, has ruled that indeed the ruling by the Speaker of Parliament should be stayed and should not be executed as directed by the Speaker yesterday in his ruling. And so for now, safety for the 4 members of Parliament, that is Cynthia Morrison of Aguna West, there's Peter Kwachi Aka of Amenfi Central, there's Andrew Siama, 2nd Deputy Speaker of Fomena, and then there's that of Suhum as well. Joining me now to have a conversation regarding all that has transpired between yesterday and now following up to this ruling is my colleague and head of current affairs here at Channel One TV and City FM, Fred Tete Jabano. Thank you so much, Fred, for joining me. Now, the Speaker has, the Supreme Court has given its ruling, which ruling stays the execution of the ruling made by the Speaker yesterday regarding this matter. Kindly help us get a proper understanding of this.
Like you explained earlier, yesterday the Speaker of Parliament made known his decision concerning the 4 seats which were being challenged by the minority, where he came to the conclusion that per his understanding of the law, the 4 MPs or 3 MPs who have decided to go independent, and the 1 MP who has also now decided to contest on a ticket of a party should lose their seats based on their decisions. Before this particular decision, on Monday, on Monday or Tuesday, we were told that the majority leader, Alex Afenyo-Mankin, went to the Supreme Court to go and seek for an interpretation of Article 197(1)(g) of the Constitution, which talks about how people can be, or MPs could be removed from Parliament. As part of his suit, he also filed an application for injunction to halt the Speaker from going ahead to make, or to hold the Speaker from reading his ruling or making his ruling known on that particular decision.
So basically, this injunction that was being sought was to stop the Speaker from pronouncing the ruling.
Exactly, from pronouncing the ruling before even the ruling was made. Let's take note that this particular suit by Alex Afenyo-Mankin was even made before the parliamentarians went back to Parliament and the statement was made by the minority leader. So yesterday, after the decision of the court, the majority led by Afenyo-Mankin this morning filed an application for stay of execution to halt the implementation or execution of the ruling of the Speaker yesterday until the substantive case is heard. The application was filed this morning. This afternoon, the Supreme Court was set up. There were 5 justices of the Supreme Court presided by Chief Justice Tokonu. And the decision was that the ruling by the Speaker has been stayed until the substantive case is heard.
Right. Now, ordinarily, you would find, or you would require the Speaker or maybe some senior officials of Parliament to be present or to participate in this hearing or this particular case. But we understand the motion was, or the petition was filed ex parte.
Yes.
And so please help us understand what
from what we are hearing, what we are hearing, as you said, the petition was filed ex parte, meaning that the applicant alone was present in court. So the other parties were not served this particular hearing. Usually when you go on notice. So Alex Afenyo-Mankin's suit, initial suit, was on notice. It was on notice. So you'd realize that while it was on notice, that means that the Speaker would be served, Parliament would be served. They would all have to respond to the issues. Then the court would come and hear the matter. But in this particular case, this case went ex parte, meaning that the majority leader and his lawyers just went representing themselves without informing or notifying the other party. So this was between them and the court. The court heard their argument and granted the case, their request.
What will be a typical stay of execution? Will it come with timelines, or the rule is that this will pend the determination of the substantive matter?
As we speak now, I haven't heard any timeline. The ruling has been stayed.
What we know is that the applicant was seeking 10 days.
That was the injunction.
For the injunction.
That was the injunction. That was the injunction. That was the injunction application. This is different from the stay. So what happens is that, when you file an injunction application, there are 2 schools of thought. Where one school of thought believes that once a party files an injunction application, then everything should come to a halt. So whatever they are looking for, whatever the issue is, should come to a halt till the court determines that injunction application. There's a second school of thought which believes that, look, the fact that you filed an injunction doesn't mean everything to come to a halt. It only comes to a halt when the court pronounces on it. You understand? So I think in this case, the Speaker and the Parliament, in fact, they said they were not served. They were not served with the writ by the majority leader. But in any case, the injunction was not heard. And the injunction, as we speak now, would not make sense because the Speaker has already gone ahead to give his ruling. So there'll be no need to come back to hear the injunction, because what you are trying to prevent has already been done. So now they went to stay the decision of the speaker, to put on hold the implementation of the decision of the speaker. So as we speak now, whatever the speaker said yesterday, where he said that 4 MPs or 4 seats have been declared
vacant,
does not stand any longer. The 4 members of parliament would continue to come to parliament to work.
Well, let's look at parliament, the legislature, as an arm of government on its own, and of course the judiciary also being an arm of government on its own, and how now it's as though, just as the MPs have done, are crossing carpets on this matter, and how you anticipate all this will play out.
You know, there's always a saying that Parliament is a master of his own rules.
Right.
But being the master of his own rules, they also fall under the Constitution of Ghana.
Very well.
Meaning that anytime they go against the laws of the country, we have the courts, which is the judiciary, which can come and pronounce and say, this particular thing you have done or this particular thing you are doing goes against the Constitution, hence cannot hold. So this is what has transpired today. Parliament has made a decision. Their decision is that, led by the speaker, or the head of the legislature is the speaker. So Parliament has made a decision. The court is saying that, look, hold on with this decision. We are not sure what the speaker is going to do with this, especially the speaker who is a believer of Parliament being a master of his own rules.
Yeah.
And he was a strong believer of the fact that their work should not be influenced by the judiciary.
Yeah.
We are not sure the decision of the speaker or the position the speaker will take. Whether the speaker will decide to heed to the order of the court, or will still insist on the fact that the court cannot direct Parliament as to how to do its work. That is one point. Now, there's the issue of a court order.
Yeah.
If you do not follow a court order, there are other remedies which can be taken when a court gives an order and you do not follow. You have disrespected the court. You can be cited for contempt. We are not sure how this will play out. If the Speaker of Parliament decides that, look, I am not going to heed to the directive and the order of the court, will the majority go back to court to ask the court or to cite the Speaker for contempt? That's another option. In the coming days, it's going to be really, really interesting, looking at all the things which have been happening. And you see, this particular parliament we are looking at is a very interesting parliament.
Very.
You see how it began on the very night they had to be sworn in. We spent almost like 6 to 7 hours. Over a disagreement, the election of a speaker, even who was majority, who was minority. All those things played out. We ended up having the independent candidate who is now a subject
of again
a subject of controversy again.
In 2020.
Yes, that's the deputy
second deputy speaker,
Andrew Esiamia, being a subject of an issue again. He has been a subject. He was a subject of that issue before in the last parliament. At the end of the last parliament, he's now another subject for controversy
again at the end of
another parliament, the next parliament. We saw everything which transpired. We even saw issues with how they dealt with the e-levy and other legislations. And now this is where we find ourselves, where the minority believes that, look, some people by law, as they believe or they understand, should not be seen as members of parliament or recognized as members of parliament based on some actions they are taking.
Exactly.
The majority disagrees. The speaker makes a decision. Now, the court says, look, the decision, put on hold that decision. Let us determine the substantive matter. The substantive matter being Article 97 1G of the Constitution as to how to remove or the processes of removing a member of parliament if he decides to go independent or decides to join a party before for the next parliament.
Right. Fred, I'll have you hold on for me. The majority leader, Alexander Afenyo-Markin, is currently addressing the media, and so we want to take a look at what he's been saying.
We are Democrats. We don't believe in violence. We don't believe in mischief and unnecessary political chaos. We came to court believing that the court will do right, and indeed the court has just done that. The rights of those MPs have been reinforced, as well as the rights of those constituents who elected them. I will leave the Ghanaian public to peruse the full ruling of the court, and then the discussions can continue. But let me thank my colleagues in leadership, especially the hard-working Majority Chief Whip, for all the support and his industry. I thank senior members of Parliament, Uncle Joe Gatti, Honorable Kennedy Japon, not the least Uncle Katie Hammond, and others who have been supporting me. Again, equally important are my colleagues in the backbench, especially those who lost their primaries. They've been with us thick and thin. The whole of last night we didn't sleep. We've been working all night. I myself, being a practitioner of our courts, made sure we put together a solid case. And this afternoon we've had justice. Now, those NDC people who are, walking all over the place, proclaiming, if they know the law, they should now face us in the law.
Quite a different Afenyo marking from the one we saw yesterday in Parliament after the Speaker gave his ruling. Today he's quite elated because it looks like the Supreme Court ruling
and a bit calmer.
A bit calmer, yes. Yesterday we saw him in a different type of mood.
Yes, he wasn't happy at all at the proceedings at the Parliament yesterday. He felt that he was not treated fairly. He felt that the Speaker of Parliament did not adhere to the laws of the country. And like he said in the just aired interview, that they believed in the law, they have gone to court, they've had the court to stay execution, and now they believe that if there's any superior legal argument, it should be made in the court, where the court would hear parties, both Parliament and lawyers of Afenyo marking, as to what they believe the interpretation of the Article 97(1)(g) should be, and the court will make a determination. So for now, they are happy because, some few hours ago, the minority had claimed to be majority based on the Speaker's ruling, and that he, Alex Afenyo marking, was now minority leader.
Right.
This was what the minority had said, and today they went on further to say, look, we are going to reverse a lot of the things which this particular government had done. So this was a majority, a worried majority.
Clearly.
A worried majority. Because, you have been majority, you have a plan, you are leader of government business, and all of a sudden it changes. People have the numbers, and now they call themselves majority. You don't even know how they're going to act. You are not sure how it will affect the whole government business. Now you are heading 2 months. It's about 2 months to an election.
A major
How
election.
does this play out? How would it even affect the fortunes of your party? So, all these things would bring about some worry. And it was what we saw today or yesterday with the majority.
And for Afenyo in particular, a young majority leader hasn't held that position for what? A year yet?
No.
He's not a year in that position.
Even with the controversy which came with his appointment as majority leader, where you had a majority leader who was removed and he was brought in. The controversy, the noise around it. National Council finally upheld that particular decision. And so the stakes were high.
Exactly.
The stakes were high for him.
He needed to act and really act tough.
Exactly. He needed to act and act fast. And that is what he did. And you see, one thing he did was also to get the senior members of Parliament to rally around him. You had the former Attorney General, Joe Gatti, actually representing him in court. So he was the lawyer who stood on his feet to argue the case out for the Alex Afenyo marking. You had Katie Hammond, another senior lawyer, a senior member of Parliament. You had several other senior MPs and other backbenchers supporting Afenyo marking in court today. You could see from the videos the excitement amongst the members of Parliament, now majority members of Parliament. So
they've held on to it, they will hold on to it very tightly.
Held on to it. But you see, for me, as I said earlier, I don't think we've seen the end of this.
No.
because the Speaker will now need to come. He will be served with the decision of the court. And the Speaker will now decide whether he's going to go with the decision of the court or would decide that, look, I'm not going to go with the decision of the court. I believe in what I have said. Parliament is a master of his own rules, and I'm going to go with what Parliament does. So there are interesting days ahead as to how this thing would continue to play out.
Let's trace back a little and see if we can draw any similarities or differences with some recent happenings in Parliament and, of course, the court. I'll take you back to when Joseph Osei-Wusu, first Deputy Speaker, presided over a matter and participated in voting. Same matter was sent to court, a ruling was made on that. And all. I mean, are there any similarities we can draw between that and this particular one?
Yes, it's quite similar, where the minority challenged the numbers of the majority at the time. I think this had to do with the e-levy, where there was supposed to be a vote. The Speaker of Parliament was not available, so the first Deputy Speaker of Parliament had to take the seat to preside as Speaker of the House that day. And with the voting, if he had not voted, it would have been a split decision. A split decision, meaning that the e-levy, passage of an e-levy would have been shut down.
Exactly.
So he came out to vote. The minority challenged this decision. It was sent to court for a constitutional interpretation as to whether this could be done. In the case of that e-levy matter, there was no stay. The Speaker read the decision and said that what his deputy did was wrong. But he did not go ahead to throw that matter away. But then the courts further went on to uphold that decision.
Right. Fred, hold on for me. The Honourable Member of Parliament for Adansi Asokwa and Minister for Trade and Industry, the Honourable KT Hammond, is joining us live via telephone. Hello, sir. Thank you so much for joining us. First off, how excited are you about this particular ruling by the Supreme Court?
I'm not excited. I knew yesterday that it was a bogus ruling by the Speaker. I knew the court would settle with the right.
Yeah, but quite some level of agitation yesterday in Parliament when the Speaker made that ruling. This stay that has been issued by the Supreme Court, how do you anticipate it plays out in Parliament when you do meet the Speaker?
The Supreme Court has made a ruling, a very clear directive. I'm going to go back. I was there, so I had a precise wording of the order. It was simply this, that the members, the ruling by the Speaker, his name was specifically mentioned by the Chief Justice, that the order made by him in respect of the 4 members of Parliament, and she respected the names, be stayed, and they be stayed, and not for, I think, the 10 days that I guess the petitioners, the plaintiffs, well, actually one, my younger brother, Afanya, was asking for, but for the entire period within which the suit pended. So it was for the whole term of the suit. That is held in abeyance pending the outcome of the entire proceedings until the court has concluded. It's a hearing. But it's clear, that's what the court has said. I don't anticipate any difficulties. The court is the ultimate arbiter of these constitutional matters. The court has said A, B, C, D, and that is it. So I expect every side to abide by it. I can't imagine the Speaker who says he's number 3, number 4, or number 2 or so, gentleman in the land, deciding to do anything otherwise. If he says that, he's in contempt of the Constitution, he's in contempt of court, and he's in contempt of everything. So he's a lawyer, he understands this. So I expect that on Monday, Tuesday, when we go back to Parliament, the Honourable Majority Leader would have his pride of place. Other members who are outside of the majority would comfortably be seated on our part of the aisle, and the minority opposition, the perpetual opposition sitters, they would be seated in their rightful place.
Honourable, is this confirmation that you are returning to Parliament to do the business
but I
of
told
government?
you yesterday, why would we vote for Parliament when the writing is done? We said yesterday we were not going to Parliament in view of, for us, a capricious, a very whimsical decision taken by the ruling by the Speaker. We thought it was wrong. We weren't talking about the law. We weren't talking about it. We looked at it. We thought politically and all of that. It was a bad decision. And in any event, for some who have some little understanding of the law, we thought that on the plain wording of it, it was a bad decision. So we agitated and said the Speaker couldn't have done that. So how that the decision, we weren't going to glorify his illegal. Speaker Bagbin has been doubled in all sorts of shenanigans and illegalities since he became the Speaker. We've had to grapple with all sorts of things that he's done. But on this one, we said that it was beyond, and we weren't going to go to that Parliament and glorify his ruling. So that's the point that we made. And you remember the caveat that until the matter has been resolved by the Supreme Court, because it was in the Supreme Court in any event, he should have held his hand, stayed away from that until the Supreme Court took a decision. He didn't. He decided that he would make the ruling all the same. He made a ruling, and fortunately, today we have the Supreme Court saying it for the sanity of everyone in the country.
Well, Honourable, how different is the ruling of Speaker Bagbin from that of Speaker Okwe in 2020 regarding the Fomena Member of Parliament?
What about it?
I mean, it was a similar situation when he decided to contest as an independent. I'm referring to the Fomena MP then, who now sits as the second deputy speaker.
Let me explain that to you.
Well.
Number one, the ruling by Speaker Michael Quay for some of us was inconsequential. Indeed, if you ask many members of Parliament, they wouldn't even recall until this matter came up. We were about 169 members of Parliament and so. So that issue didn't register on any scale, didn't register on any political scale. I myself don't recall until this thing came up. That's one. Number two, the fact that Professor Michael Quay made that ruling doesn't make it right. I mean, even the Supreme Court at whatever level, I mean, the Constitution or the various jurisprudence allows them to sit back, re-examine their own judgments and decisions and rulings, and see if they are so good for they serve the purpose. If they go by the sell-by date, they overleave their sell-by date, the Constitution, the laws allow them to revisit. So assuming that Professor Michael Quay made that ruling at the time, some of us are saying now that, well, it wasn't good then. But remember, in terms of legal jurisprudence, the decisions are always retrospective. It is that 10 years ago, 20 years ago, 40 years ago, this is how the law should have been interpreted. If it wasn't so interpreted, but it is interpreted today as such, the law as it is interpreted today and it stands today is the same as what it should have been 20, 40 years ago. So probably Michael Quay interpreted it and made the ruling that you have just alluded to. Today we are telling the court that in our respectful opinion, that ruling, remember, it wasn't binding on Speaker Bagbin in any event. But whatever that was, we said that no, it shouldn't have been so rude by Professor Michael Quay. And with a fortiori, it shouldn't have been rude this way by Speaker Bagbin.
Very well. Honourable, thank you so much. We're grateful for your time this afternoon. And
you're very welcome.
Thank you so much. That was the Honourable Member of Parliament for Adansia Sokwa, the Honourable Kobnata Hammond, who also is the Minister for Trades and Industry, speaking there regarding the ruling by the Supreme Court, or the decision rather, by the Supreme Court to stay the execution of the ruling of the Speaker of Parliament, Alban Bagbin, regarding the declaration of some 4 seats as vacant. These seats belong to the Member of Parliament for Gomua West, Cynthia Mamle Morrison of the New Patriotic Party, Kwadwo Asante Suhum MP on the ticket of the New Patriotic Party, and of course Peter Kwachi Aka, who represents the NDC in the Amenfi Central constituency. Then there's that of Andrew Esiama, who currently is an independent member of parliament, but has filed to contest the 2024 general election as a parliamentary candidate for the New Patriotic Party. It is these 4 seats that the minority filed a motion in parliament to have declared vacant, which ruling was given yesterday by the speaker, declaring the seats vacant. The majority side, who had already been in court today, have had their case heard, and the decision by the court is to stay the execution of the speaker's ruling. Let's speak to the Director of Legal Affairs for the National Democratic Congress, Lawyer Eduji Tamaklu. Thank you, sir, for joining us. And let me ask you what you make of the ruling or the decision by the Supreme Court.
So, first of all, this ruling is extremely strange. You understand?
How so?
It looks extremely strange. First of all, the rules of the court allow that when an application is filed and a party decides to abridge time, which I understand is what happened today, the motion for abridgment of time should not go as parte.
Okay.
It is not the case that the MPP in Parliament have been stopped from working. They voluntarily pitched a walkout. Walkouts are normal with proceedings of Parliament. So now when you take the positive step of walking out of Parliament, it will not be heard from you to say that Parliament should injunct the doing of something because of ABCD2. This is not the first time a member of Parliament has been declared vacant by a speaker. As you rightly stated earlier, Speaker Michael Quinn, in fact, vacated the parliamentary seat for Formina. Now, I understand the Supreme Court said the vacation of those seats had created a lack of representation for the people for the affected constituency. And for that matter, there was the urgent need to, as it were, stay. In any case, it's the ruling of the Speaker and the executable order. You understand? It is not an order coming from the lower court or whatever. Then the court can say we are staying its execution. This is the ruling. It does appear that this particular decision by the Supreme Court would most definitely put the Supreme Court on a coalition course with Parliament. Now, may I ask a simple question? If Speaker of Parliament instructs the Marshal not to allow the 4 MPs presence in Parliament, what would the Supreme Court do?
Will that not be in contempt of the court?
And then what next? And then what next? You are going to cite Speaker of Parliament for contempt and go and put him in prison. Have you seen the chaos we are about to create? Look, I think that with respectfully, I think we are beginning to test the patience of Ghanaians. And this experiment called democracy, it's extremely dangerous. Look, me as Director Legal for the NDC, I'm extremely worried with what has happened. I'm getting a feeling that we'll wake up one morning, John Hammond is declared winner, and a group of judges will just say, no, we don't agree. And we are setting it aside. You see, I have always maintained there's a way you can act with finesse in a manner that does not suggest any other thing. And that's not what happened today was first party. So even, let's see, call the lawyers for speaker, right? Let them even appear in court even on Tuesday. Let there be a semblance that they have been heard and the court took this decision. An event happened yesterday. A motion for abridgment of time was filed this morning and heard today, and a decision given. What is the urgency? Huh?
So
Where
I mean,
is the urgency?
Aduji, so aside the motion for abridgment being moved today and being heard.
What has happened today, that honestly, I'm really scared for this democracy.
Let me find out from you. I mean, putting the motion for abridgment aside, and the fact that there was also filed ex parte, and so no responses were taken or reaction from the speaker and his lawyers. Are you not worried about the decision itself?
No, you see, the decision is as good as the process leading to it.
Very well.
You understand? Where is the urgency for the ex parte? And you know, usually even this court has always acted with extreme hesitation. Now, for instance, an order of this nature, the court will ordinarily do it an interim order for 10 days. Then all the parties will now come and the court will hear all the parties on notice and possibly stay it, pending the determination of the matter. What has happened today scares me. But you see, look, I've always maintained that the danger with such ruling is that it comes back to hurt us. Our friends in the MPP have been offered the opportunity to learn. But you see, they have this behavior of Kwekwanansi. You know that figurative district Kwekwanansi? Not it all. But first of all, what has brought us here was the bizarre decision by Speaker Michael Pay in 2020. I was expecting the MPP to have learned a lesson from what has happened. But it appears that there is no elder among them.
Well, when you say Speaker Okwe's ruling was bizarre, was there not basis then for that ruling?
Look, you see, I have always maintained that the issue of representation is a very serious matter.
Right.
To go to parliament and elect somebody is a serious matter. You understand? It's a very serious matter. And I've always maintained that, listen, in the wisdom of the framers of the 1992 Constitution, possibly they were minded to reflect on the events of 1979. When after the 79 election, okay, the likes of Kwekuba, who were elected on a different political party, went to parliament and denounced that party and became, quote-unquote, floating MPs, and still wanted to stay in parliament after they have moved on. And you see, there is an inherent mischief, which the framers of the 1992 Constitution learned from what happened in 1979. And so we're careful in crafting this provision as a safeguard against that constitutional mischief, where, for instance, I, Eduji, I know, possibly I'm an NDC person, but I believe that I want to be MP in Bantama. Knowing that Bantama is a stronghold of, say, MPP, I quickly changed 10 codes, become an MPP member, go and win the seat as an MPP member, and wait. Some few listeners say, no, I'm going to contest the next one on the ticket of... And you say, no, allow me. Because you see, the thing with parliamentary thing is that there's no duality.
Right.
There's no duality in the sense that you cannot go to parliament on the ticket of two political parties. It can only be one at every point in time. You understand? So, this, in the superior wisdom of the framers of the Constitution, mindful of what happened in 1979, remember Kwekuba stayed on until 1981 when the coup happened. You understand?
Right.
So when we were doing the 1992 Constitution, we had that in mind and provided this constitutional provision as a safeguard to cure that mischief. Now, you have a situation where a Speaker of Parliament takes a particular decision. And then the court says, Speaker, we are staying. You know the effect of this particular ruling? Do you know the effect?
Tell us about it.
The effect is to make nonsense of the Speaker's ruling. That's what it is.
That's in your
Complete
assessment.
Nonsense. Oh no, it's to make nonsense of the Speaker's decision. Because he is pending the determination of the matter. We have how many days to the next election? 50 days.
Right.
How long has the SQQ decision been in the court? From your own reckoning, is it no more than 90 days? Even that one we have not resolved. God, have mercy on us.
Lawyer Eduji Tamaklo, thank you so much for your time.
You're most welcome.
Godwin Eduji Tamaklo is the Director of Legal Affairs for the National Democratic Congress, NDC, speaking to us there on the matter of a decision by the Supreme Court staying the ruling of the Speaker of Parliament regarding some 4 seats that have been declared vacant by the Speaker. These 4 seats being Fomena, Agona West, Suhum, and Amenfi Central. 2 belonging to the New Patriotic Party, 1 independent, and 1 belonging to the National Democratic Congress. My colleague Fred Tete Jabano still here with me. Fred, we've heard from Adansi Asokwa MP, KT Hammond. We've heard from Director of Legal Affairs of the NDC. Varying positions, obviously as expected. But what do you make of their own interpretation of what has transpired so far?
Nana, I mean, for interpretation, everybody has their own interpretation based on interest. Based on interest, purely based on interest. As I said, we are heading to an election, and as politicians, a lot of the decisions they take is based on interest and how it would benefit them. The minority, obviously, through the Speaker, had their way.
Yeah.
The majority, through the court, have also had their way. So it's all about interest. And for me, I'm looking forward to Tuesday when the House would reconvene. As I said earlier, the court has made a decision. We know that we are all bound by the decisions of the court. But the question is, will the Speaker of Parliament adhere to what the court has said? It's a decision the Speaker would need to take. And based on whatever decision the Speaker will take, it will determine the way forward for Parliament in this country. If the Speaker decides that, look, I'm going to heed to the stay, it means that Parliament is going to continue the way it has been been for the last few years. If the Speaker comes and says, look, I disagree with the decision of the court, I am not going to adhere to that decision, it's a different story. It raises issues of contempt. It raises issues of how Parliament would even now continue its working. So there are a lot of things expected, and Tuesday would be a critical day for us as a country to test the democracy of this country, the democracy we have been practicing since 1992. This Tuesday will determine where this democracy may lead us in terms of the legislature. So we should all look forward for Tuesday and see what will happen. For me, I pray that both parties sit down, come to an understanding, and let's run the country the way it's supposed to be run.
It'll be interesting to see how all this plays out. I mean, one, for a Speaker whom we have seen and heard on a number of occasions take a stance against the court. He himself a lawyer, but on a number of occasions spoken very boldly about some issues between Parliament and the court, and even sometimes between the executive arm itself. And then on the other hand, it will be interesting to see, we've heard from the Director of Legal Affairs for the party, the NDC, but it will be interesting to know, see and hear what the minority itself, led by Dr. Kesiolato Forsen, has to say and what their position is on all this, bearing in mind that they are already preparing to ignite or trigger processes to move to the other side of the House.
Yes, and I don't be surprised that in some few minutes or hours, you would hear a statement, you see a statement, or you hear...
Or even a press conference.
Being organized by the minority in Parliament to also make known their views on what has taken place this afternoon. As I said, and I'll continue to say, they are politicians.
Yeah.
And for politicians, especially some few days or weeks to an election, the interest of the politician and their political parties and whoever they represent would come to play. I doubt standing here that the minority would release a statement, would organize a press conference and say they agree with the court.
No.
I doubt that
I
will
doubt
happen.
same too.
I'm sure they will raise concerns with what has transpired today. Already, you can glean from what the director of legal for the NDC is saying, and you could have an idea of what the minority stance would be. They are raising concerns as to the filing of an application in the morning, and in the afternoon, the Supreme Court sets a panel, is heard, and a decision is taken.
So the urgency with which
the
this
agency
matter was heard.
with the matter was taken. I'm sure the minority would raise other cases before the court and ask and question where what that agency is. They are going to ask questions like the director of legal said, how come we were not served as per the rules of court?
Right.
All these questions will come out, and we expect that they will make their concerns known. And on Tuesday, as I say, Tuesday is the day we should all watch out for.
Right. Fred, let us get some legal perspectives to this matter and speak to private legal practitioner Justice Abdullahi. Good afternoon, sir, and thank you for joining us.
Good afternoon, Nana.
Good to have you. Now, I mean, first off, let's look at the motion being moved this morning, not at any other court, but at the Apex Court, the Supreme Court, and of course, the motion for abridgment, and the fact that a decision has come as soon as it came. The NDC seems to have some concerns with this. I want to find out from you, is this unusual?
It is definitely unusual. It's not just the NDC. I think that all of us should feel a bit awkward. In fact, we should all feel awkward about how, the speed with which the Supreme Court has handled this matter. In fact, not just the Supreme Court, any other court handling this matter with this level of speed will be a complete surprise to everyone and anyone. Almost every legal practitioner would agree that this is the most amazing thing to have ever happened in legal jurisprudence. And the Supreme Court you can file an application at the Supreme Court, get the application listed today, get the court constituted today, and get the decision delivered today. With the speed of light, it's such an amazing thing. And I do not think that anyone would be, there must be something pushing this for us to come to this conclusion. And it's just surprising. And even the order itself, it sounds a bit questionable. That an order to stay the execution of this of the decision of Parliament. I do not know how it doesn't sit well with me. To put it bluntly, it doesn't sit well. But that is the Supreme Court. Whatever decision they want to make, they make when they deem it right. But there are a lot of questions. There are really too many questions.
Now, ordinarily, what was expected to have happened regarding such a matter?
Okay, so at this moment, I do not even know whether the application was ex parte or was on notice.
The initial application was ex parte.
Look, so if it is an ex parte, usually getting the court to even sit on that will take you, on the average, about a week or a little more before you get a court constituted for that purpose. And so that happening today, even with the regular court. When you file the application, you have to go to Judiciary headquarters to the appropriate court to be made. And that alone takes a bit of time. Usually, I think the decision returns on Thursdays or thereabout. And so, regularly, it will take you about a week. And the Supreme Court does not just sit. The Supreme Court also constituted the Supreme Court to sit on a matter. But that takes even more time than the regular court that you have just one judge sitting. It then comes to the other side of it. for a Supreme Court to sit on a Friday, it is just so unusual. I mean, the Supreme Court hardly would sit on a Friday. What happens? I mean, on an everyday thing, the Supreme Court will be sitting on a Friday. And similarly, they don't sit, only sit on Mondays. In fact, they don't even sit on Mondays at all. And so, I mean, all these happenings kind of raises too many questions. But as to whether those questions are legally right to supplant the decision, it's a question that I think we may probably have to deal with on another occasion when we are fully with the issues and the decision that are handed down.
An order of the Supreme Court staying the execution of a ruling of the Speaker of Parliament, how much of a test does this put our democracy through?
Well, once it's coming from the Supreme Court, I think that there are two things here. First of all, the decision as handed down does not automatically come into play, so let's remember that. It has to be served on the appropriate parties in Parliament before the decision to obey or not to obey, or to challenge or not to challenge, could also come out. So, that said, I think outside of the questions that we have, the decision, for me, it reinforces our fidelity to the law, really. The fact that the minority, that's the MPP, did not take, the steps that they were issuing and all the things that we were talking about, as if we were almost at war. For me, that not happening is positive, that they use the law to get their case across. However bad it may be, I think that it shows our fidelity to the law, and it shows how tolerant, if you want to call it, that we are all to administer and then indeed develop our country with the use of the law. However insidious it may be, the fact that we are using the law to advance our cause of democracy, the cause of democracy and national development, should be crucial and should be the most acceptable thing. And for me, that is positive. That is the positive side of this whole thing, if you want to look at it from that angle.
Very well. The Speaker is bound constitutionally to abide by this decision of the court. If he chooses to disobey, what is the worst that could happen?
Okay, so first of all, the Speaker does not take decisions from the media. And so until he's appropriately served with this decision of the Supreme Court, the Speaker cannot be said to be disobeying any decision of the Supreme Court. Second, I do not foresee the possibility of the Speaker disobeying when he is appropriately served, disobeying this without any sufficient grounds. I think that if the Speaker, but granted that all things being equal, he decides to disobey the orders of the Supreme Court, that would put us into yet another constitutional conflict, and which would be resolved only when we get there. I think we come to that discussion, and maybe depending the circumstances of it would detail out how we discuss and resolve these matters. But I don't foresee that happening there.
Counsel, thank you so much for your time this afternoon.
For God and country always.
Grateful. That's Justice Abdullahi, a private legal practitioner, giving us some legal perspectives regarding the matter of a decision by the Supreme Court to stay the ruling of the Speaker of Parliament, Alban Kingsford Sumano Bagbin, regarding a petition by the minority side demanding that some 4 seats, Agona West, Suhum, Amenfi Central, and Fomena, be declared vacant by virtue of the fact that 3 sitting MPs, 2 on the majority side, that's the MPP side, and 1 on the minority side, have elected to contest the 2024 general elections as independent candidates. And then, of course, Andrew Esiama, Fomena Member of Parliament, independent now, deciding to contest the upcoming polls on the ticket of the NPP. I'm still in studio with my colleague Fred Jabano. So now we've heard some legal perspectives to it. The fact that it is binding constitutionally on the Speaker.
Yeah, if he's served appropriately.
Served appropriately, yes. So there are processes that
to serve the Speaker.
Yes,
with the ruling. Once the Speaker is served and it's deemed that he served appropriately, he needs to respect the decision of the court. And it's, as I always say, we are all supposed to respect the decisions of court. But there have been times when people have decided to ignore the decisions of the court. So it is up to the Speaker to decide to respect the court. He's bound by the decision of the court. There's no two ways about it. He's bound to respect the decision of the court. But he also has a choice of his own. This is a personal choice.
And face the consequences
the consequences thereof. That we cannot determine. But for the decision by the court, he's bound to respect it. So we would see whether the Speaker would be served appropriately when he will be even be served. The decision, the court ruling was made today. I'm sure the lawyers of the majority leader would ensure the ruling is ready, the certified ruling is ready. They would send it to Parliament and would appropriately serve the legal department of Parliament. When you hear even the Speaker's ruling and the back and forth after the ruling, there was an argument as to how the Speaker should be served, and we are told by the minority leader or the majority leader. I think it was the majority leader, Alex Afenyo-Markin, that the Speaker asked that the legal department should take service of any court case on application on Mondays.
Right.
So Parliament is open to take any court document or court issue served on any member, including the Speaker, on Mondays. So I'm sure that on Monday, the lawyers of Alex Afenyo-Markin would appropriately serve the Speaker with a decision of the Supreme Court.
Very well. Thank you so much, Fred. Fred Jabano is my colleague here, ChannelOne TV and CTFM. He is the head of the current affairs desk. We've been looking at that decision by the Supreme Court staying the execution of the ruling of Speaker Alban Bagbin regarding the petition by the minority side to have some 4 seats of Parliament declared vacant. What ruling led to this decision by the Supreme Court? Let's take you back to the House of Parliament, which of course is sitting now at the Dome at the Accra International Conference Center, to hear what exactly were the words of the Speaker of the House, Alban Bagbin.
The issue of interpretation and enforcement of the Constitution lies in the bosom of the Supreme Court and not that of the Speaker. And so I proceed to tell you my understanding of Article 97. Honorable members, at the core of the majority leader's statement are the provisions of Article 97(1) of the Constitution of Ghana, 1992, which govern the circumstances under which a member of Parliament shall vacate his or her seat in Parliament. The relevant sub-clauses of the provision read as follows. Article 91 states, a member of Parliament shall vacate his seat in Parliament. G, if he leaves the party of which he was a member at the time of his election to Parliament to join another party or seeks to remain in Parliament as an independent member. Or H, if he was elected a member of Parliament as an independent candidate and joins a political party, unquote. Honorable members, my humble view is that Article 97(1)G and H operate to prevent what the old school refers to as cross-carpeting or carpet crossing, as witnessed in the early legislative councils and parliaments of the Gold Coast and the Republic of Ghana, respectively. cross-carpeting is now part of what is referred to as defection or party switching, when a member of parliament who was elected on the ticket of one political party leaves that party to join another, or when an independent member of parliament joins a political party after being elected as an independent member, or a party member acts similarly. The concept of defection raises significant concerns about the integrity of political representation. When voters elect a candidate, they do so based not only on the individual's personal qualities, but also on the political party platform they represent. Party switching or defection, therefore, can be seen as a breach of the mandate and social contract between the member of parliament and the electorate, as it changes the political dynamics that the voters originally endorsed. The prohibition of defection, as reflected in Article 97(1)(g) and (h), serves several critical purposes in maintaining the integrity of Parliament, parliamentarians, and protecting the trust and will of the people. The provisions of Article 97(1)(g) and (h) are designed to safeguard the principles of party loyalty, voter representation, and political stability. Defection is prohibited because it undermines the trust placed in members of parliament by their constituents and can lead to instability in parliament. These constitutional safeguards ensure that members of parliament remain accountable to both their parties and the electorate, and they prevent members of parliament from engaging in behavior that could amount to fraud or disruptive of the functioning of parliament. Honorable members, it has been suggested by some members that the provisions of Article 97(1)(g) and (h), which address the vacating of a member of parliament seat due to defection, should be understood prospectively. That is, they should apply only to future parliaments and not to the term of office of parliament when the act occurs. While this argument may appear to offer a practical approach, it must be firmly dismissed as both untenable and inconsistent with the constitutional purpose of these provisions. One may ask, what is Article 97 purposed to do? The clear intent of Article 97(1)(g) and (h), to my understanding, is to preserve party loyalty, engender trust, and protect the mandate of the voter and representation throughout the MP's term of office. These provisions are designed to prevent political instability, as I stated, opportunistic behavior, fraudulent representations, and disruption of parliamentary composition during the term of a parliament, by ensuring that members of parliament remain faithful to the mandate given to them by the electorate at the time of their election. To understand these provisions as only applying prospectively, meaning that they will take effect only in future parliaments, will nullify the purpose of Article 97. The provisions of Article 97 and the consideration are intended to address breaches of party loyalty and independent status as they occur during a term, ensuring that the House's composition remains consistent with the electoral outcomes. If Article 97(1)(g) and (h) were to apply only in future parliaments, it will render these provisions effectively superfluous. By the time the next parliament is constituted, any member of parliament who has defected or switched political allegiance during the current parliament will no longer be in violation of the provision. they will start the next term aligned with their new party or as an independent. There will exist no defection, and the violation will effectively be wiped clean at the start of the term of the succeeding parliament. If the understanding of the provisions was futuristic, members of parliament could freely switch parties or become independent during the term of a parliament and pretend to be representing the interests of the people who elected him or her or the party on whose platform he or she wrote to parliament, while paying loyalty to a different party or group of people with no immediate consequences. This is precisely what Article 97(1)(g) and (h) are meant to prevent. The provisions exist to curb, as I stated, defection, as it happens, not to offer a free pass to members of parliament to change allegiance during their term and only face no consequences, even in future electoral cycles. Under Article 97 of the Constitution of Ghana, there are indeed different modes through which a member of parliament shall vacate his or her seat, and these can be broadly categorized into two groups. The A is the one that we refer to as automatic or procedural, and the B is a matter of determination of fact. Certain modes of vacating a seat happen automatically or procedurally, either through the direct operation of law or institutional processes. These are relatively straightforward and do not require external determination of facts. For example, the dissolution of parliament, the election as speaker, the expulsion for contempt, and resignation of a member of parliament. The second category deals with others where you require determination of facts. And those are the other provisions identified in Articles 97(1), C, E, and D. These involve more complex factual situations that are less clear-cut and may be subject to dispute, making them matters that likely require determination to ascertain whether a vacancy has occurred. Honorable members, it is important to note that the determination of whether a member of parliament has resigned from their political party or has joined another party is a matter of fact. In 2020, during the tenure of Right Honorable Professor Aaron Michael Quay as Speaker of Parliament, a notable instance occurred when the New Patriotic Party notified the Speaker that the Member of Parliament for Formina, Honorable Andrews Asiema Amwako, was no longer a member of the party. The MPP requested that the seat be declared vacant in accordance with Article 97(1) of the Constitution, citing that the Member of Parliament had filed to contest the upcoming elections as an independent candidate, which violated the party's constitution. In response to this request and notification, Right Honorable Professor Aaron Michael Quay proceeded to declare the seat vacant. However, I must emphasize that this ruling made by the previous speaker does not bind other speakers, including myself. It is important to point out that in the present matter before the House, the notice of poll is available at the Electoral Commission on all the 275 constituencies. I have duly taken note of the notice of the poll, and furthermore, no member in making comments to the statement made to the House by the minority leader denies these glaring and notorious facts. And so, what is my role in all this? Honorable members, it is important to point out that the Speaker is called upon by the standing orders of Parliament, particularly Order 18, to inform the House of the occurrence of a vacancy of the seat of a member under Clause 1B to E, G, and H of Article 97 of the Constitution. Accordingly, I proceed to inform the House that by the notification of the polls, the following members of Parliament have by their actions vacated their seats in Parliament. The members are Honorable Peter Yao Kwashi Aka, NDC MP for Amenfi Central in the Western Region, now referred to as an independent parliamentary candidate for the same constituency. 2, Honorable Andrew Amwako Asiama, independent member for Fomna constituency in Ashanti region, now referred to as MPP parliamentary candidate for the constituency. 3, Honorable Kojo Asante, MPP MP for Suhum in the Eastern region, now referred to as independent candidate for the same constituency. And finally, Honorable Cynthia Mamile Morrison, MPP MP for Agona West constituency in the Central region, now referred to as independent candidate for the same constituency. These MPs cannot be allowed by law and my good self to continue to pretend to be representing people that they don't believe in and they don't have any loyalty for in this House any longer. The House is accordingly so informed. Honorable members, I thank you for your patience and attention.
So that was the Speaker of Parliament, and given his ruling, that was yesterday in Parliament, regarding the petition by the minority to have these 4 seats declared vacant. Right, so this is the ruling that has been challenged by, of course, this abridgment of time motion moved by the majority leader in court today. The court today has stayed the execution. Now, there's another leg to this because the court, in granting the application, directed lawyers for the Speaker and the Attorney General to submit or to file their statement of case. And then jointly file a memorandum of issues on the October 15 case presented by Afenyo Makin.
Exactly.
So what does this actually mean?
So then what's going to happen is that the lawyers of the Speaker would have to respond to the suit by lawyers of Afenyo Makin, and then together they decide as to the question they want the Speaker, the Supreme Court to answer. So usually when you bring such cases, the 2 parties are given an opportunity to sit and discuss what do we really want the Supreme Court to answer, what are the questions we want the Supreme Court to answer. When they do that or they do not come to an agreement, the court itself will now give and decide on the question they would be answering in the hearing.
Question and then
no, they'll look at the suit and then give you that these are the things we are going to answer with this, your suit you have brought. So it all falls within the suits that have been brought before the court. So the court will do that. Then
so sorry, this is what it means when it says file a joint memorandum of issues.
Yes, joint memorandum of issues. So what are the issues the court is supposed to address? What are the issues or questions you want the court to answer? The 2 parties sit together. A lot of times they are able to come up with the issues. Sometimes 2, sometimes 3, sometimes 4, depending on what the issue is or what the case is. Then, if they are not able to do that, the court itself will come out with its own issues, would listen to the addresses of both parties, then come to a determination. But Nana, this is very important because this particular suit is very important because, you see, we've seen a Speaker of Parliament, an old Speaker of Parliament, make a particular decision which people disagreed with. Come to a next Parliament, another Speaker has made a similar decision. It may be different circumstances, but they've made a similar decision. I think this case before the court is a very important one because the court will bring to a finality what it means to go as an independent or to run for another party as an independent for a next election, not within the same parliament. You understand? The concern now has been, look, I am in a particular parliament. I have decided to run as an independent for the next parliament. How does that affect my work within this present parliament? And it's been a back and forth, and every speaker comes to make its own ruling. You know, this issue of members of parliament going independent or joining political parties is not going to end.
No.
The fact that we are going to have parliamentary elections every 4 years, it would come up. So it is now time for the Supreme Court to give a direction, to really interpret the law and give us really what did the framers of the law mean with Article 97, 1G of the Constitution. So that going
then
forward,
the retrospective nature of the same law.
And going forward, then we are all guided by that interpretation by the court, so that we'll stop all these issues and this confusion which takes place in every parliament.
It's interesting that the Speaker Bagbin today is the one giving this ruling, because in previous times he has been the petitioner in similar cases.
Exactly. You see, that's what I'm saying. You see, if we leave it to the politicians, it's going to be interesting.
He actually predicted that this matter will come back.
Actually, yes, he did.
Because he knew it.
Actually, he did. He did. And even the member of parliament for Boku Central 4 years ago really challenged the decision of the speaker and even urged Honorable Esiama to go to court. You know, for politicians, it is interest and would always be about interest. I think to be able to really stop interest when it comes to law, we need to make a definite declaration. And I think the Supreme Court's decision, which would come, would be a definite declaration as to what that part of that article of the Constitution means and how we should run with it going forward.
So until the memorandum of issues is submitted or filed, will we know exactly what it is, say the petitioner in here or applicant Afenyo Makin is seeking?
Yes, no. So right now we know what he's seeking. He's seeking for an interpretation of the Article 97, 1G of the Constitution, which has
an H,
which talks about how all these things play out. That is what he's seeking. But with the issues to be addressed, the substantive issue is there. That is what the Supreme Court would address. But usually there are issues they would lay out, and out of those issues, the main or the substantive concern is addressed. So we already know what Honorable Afenyo Makin is looking for. What we would be looking for his statement of case. That we know that it's going to explain his position and what he's going to argue for. You understand? Whether he's going to argue that that particular provision of the Constitution means that once you decide to go independent, you are no longer a member, or you should vacate your seat. You understand? Or once you decide that I'm going to run as an independent person running for a political party, you should vacate your seat. Or he's going to take the other side of it, which says, no, this is not what it is. You can remain in parliament if you are contesting for an election as an independent who is coming from another political party in the next general election.
Very well.
We are not, as of now, I am not sure which position Afenyo Makin holds now, but going forward, as the court has directed, they are going to file all their statements and then would really understand the position of Afenyo Makin as to between the two arguments where he really stands and where the Speaker of Parliament also stands. And I'm sure the AG would also give a position on where it also stands.
Right. Fred, let's hear from Afenyo Makin, the majority leader, once again after proceedings ended in court today.
We are Democrats. We don't believe in violence. We don't believe in mischief and unnecessary political chaos. We came to court believing that the court will do right, and indeed the court has just done that. The rights of those MPs have been reinforced, as well as the rights of those constituents who elected them. I will leave the Ghanaian public to peruse the full ruling of the court, and then the discussions can continue. But let me thank my colleagues in leadership, especially the hard-working Majority Chief Whip, for all the support and his industry. I thank senior members of Parliament, Uncle Joe Gatti, Honorable Kennedy Japon, not the least Uncle KT Hammond, and others who have been supporting me. Again, equally important are my colleagues in the backbench, especially those who lost their primaries. They've been with us thick and thin. The whole of last night we didn't sleep. We've been working all night. I myself, being a practitioner of our courts, made sure we put together a solid case. And this afternoon we've had justice. Now, those NDC people who are, walking all over the place, proclaiming, if they know the law, they should now face us in the law. This is the majority leader.
So that was the majority leader, Alexander Afenyo-Markin, speaking there after court proceedings today, which court ordered that the ruling by the Speaker regarding these 4 seats, Agona West, Memphis Central, Suhum, and Fomena, be declared vacant. That was the reaction after the court proceedings. So the 8th Parliament, quite an interesting one. I mean, from how it began to how it is ending.
It began with confusion, and we are hoping it doesn't end with confusion.
We hope so.
Yes,
we hope so.
Yes.
We hope so. But it's been quite an interest. We've seen how the numbers game has really been played out in Parliament.
Exactly.
This actually is also a numbers game being played.
No, we all called for a hung Parliament where we thought that then the government will be put in check and members of Parliament will now perform better. I don't believe that this is the kind of Parliament we'll ever want again as a country now. I don't think our democracy is ready for this kind of Parliament. This present Parliament has shown us that, look, this hung Parliament system wouldn't work for us now, maybe in future, because the kind of confusion and disagreement we are seeing, and we thought that with this Parliament, there would be a lot of there would be a lot of conversations and agreements and understanding, but it doesn't look like that. We hope and pray that as we head towards 7th December, 7th January or the 6th of January, there will be no longer confusion. We'll learn this Parliament will end in peace.
Very well. Very well. Thank you so much. Fred Tejabano is my colleague here, ChannelOne TV and City FM. He's also the head of current affairs. My name is Nana Tufo Boateng. This is the Election Bureau. Stay with us for comprehensive coverage of the 2024 elections. And you can join the conversations with the hashtag Ghana Polls 2024, hashtag CityVerify, hashtag the Election Bureau. Keep watching ChannelOne TV.